Now continue with the program based on what you've seen and what you've heard. And I would call upon Mr. P H Parekh, the noted senior advocate of the Supreme Court and the former president of the Supreme Court Bar Association. I know he doesn't like to drop names, but I might tell you that Parekh Saab has been actually the guru, where people like Justice Chandrachud and Justice Mudgal were his juniors at one time. I know he doesn't want me to drop names, and he's very embarrassed when I say this, but I introduce him with great pride to this august audience, to you, ma'am, and to you, Mr. Chief Justice.
Your Excellency, the Governor, my dear friend Chief Justice of the High Court, Justice Singh, Mr. Vardhwan, Mr. Rai, ladies and gentlemen. Our Constitution framers provided for justice. Yes, it has given Supreme Court, High Courts, and the subordinate courts. It has given fundamental rights to the citizens. It has given equality, Article 14, liberty, Article 21. Each one of these articles has been interpreted by our High Courts and Supreme Court in a purposive way, in a way that the citizens get the justice which our Constitution wants to give. In fact, it is more important that the lowest of the low in the country, socially, economically, gets the justice. The rich people have enough means probably to solve their problems with the government, with the bureaucrats. Is the poor who cannot solve any problems, and they need justice. And therefore, access to justice. Yes, of course, access to justice our Constitution has provided, because it has given to the Supreme Court the writ jurisdiction. If your fundamental rights are violated, you can directly go to Supreme Court. You need not go to the lower court, you need not go to the High Court, and Supreme Court will entertain directly. The Constitution, good old days, when I started my practice in Supreme Court in 1969, 5 judges used to sit even to admit a writ petition, because the Constitution says that at least 5 Supreme Court judges will sit to decide any writ petition, including admitting a writ petition. Later on, of course, due to the problems of shortage, the judges said if the matter is already covered, then it can be heard by 2 judges, and for admission it can be heard by 2 judges, and so forth. Therefore, the access to justice becomes very important. Justice is there on paper. Justice is there in the Constitution. Justice is there in large number of legislation made by Parliament and the state legislatures. But how does a citizen get to obtain the justice? Of course, the legal aid system is made, in which all women, all persons belonging to scheduled castes, scheduled tribes, and all poor people will get free legal aid. They can go to the legal aid societies. Now, the Parliament could not have done better than entrusting the entire legal aid movements in the hands of the legal fraternity, and by legal fraternity I include judges and lawyers together. They have appointed the head of the legal aid in the country, the Chief Justice of India, by designation. Whoever is the Chief Justice of India is by Parliament statute says that he is the head of the legal aid. They have made the Chief Justice of a High Court as the head of the legal aid in the state, and they have made the district judge as the head of a district legal aid. And this Parliament did because it thought that rather than bureaucrats or the ministers or the bureaucrats handling this legal aid, let it be done by the judiciary itself. The trouble today is that a litigant is afraid of going to legal aid, and I'm very sorry to say that I'm connected with the legal aid, I'm connected with the middle income legal aid. A litigant has an apprehension that if I go to legal aid, I will not get the good justice, I will not get the justice which a man who pays the fees to a lawyer. And I must blame our fraternity of lawyers also. We have also become commercialized. Higher the fees you charge, greater your status. I don't mind lawyers charging. Good old days when Mr. M.C. Setalwar was the Attorney General for India, he had made a rule that in Supreme Court, no senior advocate will charge more than rupees 1,040 for a admission matter. If it comes second time, 640, and for final hearing not more than rupees 1680 per day. Today everything gets into lakhs, and some of our chaps go into crores also, which is very unfair, because where is the justice then? If a man can't pay so much of money, he has no justice. The best talents is sold, if I may say so, and I'm saying against me and my fraternity. And that is what is trouble. And of course, the judges and lawyers, we have been discussing access to justice. Large number of seminars are held from time to time, and we all do try our best. I don't say that judges and lawyers don't do anything. We do try and do something for us. But I'm very glad that media, I'm very glad that India Legal and APN have taken up this. It is very, very important. Now the media enters our household, it enters our bedrooms 24 hours a day. And therefore, we also, they call it idiot box, but we are also idiot. We keep on switching on all the time. And therefore, media is there all over. And I'm very, very, and I congratulate the India Legal to start this, and this will give some more impact. But at the end of the day, I think it is for us, the judges, lawyers, and any other citizens who want to do something, that it is for us to ensure that access to justice is available to the poorest in the country, to the lowest in the country. By lowest, I don't mean lowest in the sense, in our strata lowest. And if that happens, then I'm sure that the beginning which is done today will become successful. Thank you very much.
Thank you, Parekh Saab. That was short, sweet, bittersweet, and very informative, as I'm sure as all of us expected.